So thank you everybody for joining us. I think it's a really interesting topic, and I think as AI models are becoming increasingly more advanced, I think all jurisdictions are grappling with how we can regulate them and perhaps provide a framework to allow businesses to use and develop AI in a way that is ethical and in compliance perhaps with good practice. So perhaps to set the scene, I could ask everyone to sort of introduce and talk a little bit about what the regulation looks like in their jurisdiction. So I'm going to start with China, where I think China's recently issued the AI interim measures. So I guess it would be great to hear a bit more about what they look like and how comprehensive that framework is.
Yeah, sure. Thank you, Susie. I'm glad to join this roundtable discussion on the AIGC. It's quite a exciting topic, as we know that with the technology advancements really rapidly in this area. So we got a lot of the high-tech company trying to put a lot of stake in this area. So the government also moved very quickly in China, and as Susie just introduced, China recently issued an AI interim measures and just laid down a basic framework for the regulation of the AI technology. And in brief, these measures only apply to the service that use the AIGC technology to provide some generated content such as text, images, audio, and video to the Chinese public. So basically, no matter from the domestic or foreign technology providers will subject to these measures. And I think the logic of these measures is quite simple, and they just divided to the AI industry into two areas. The first area is a company who developed such AIGC technology. And second area is some kind of a service provider who use AIGC to produce their service. And I have to say that this kind of a regulation, the measures is quite immature. They just supply some basic, the principle and guideline and how to deal with the AI. The measures just provide an insight. They want more transparency and safety, accountability for the AI service provider. I think one thing that's important to be noted here, they basically put a lot of liability for the supplier of the AIGC service, and they just want to make sure that from the sales of the content, which is high-tech company who supplied the AI service, they could abide with the regulation, and they could, to take every measure to ensure that their content is safety and compliant with a different area of the laws, current laws, including the intellectual property protection and some protection on the personal data and the compliance with other legal regulatory, such as the data security law, and some cyber security law and personal information protection law. And one thing to be noted here, I would say it's quite, unique to China that we have such kind of recordation requirement. That means if certain AIGC service has been deemed as has a capacity to, mobilize the social movement or have some kind of a power to encourage some media coverage, that requires such company to to go through a kind of a recordation procedure before the government and to go through some security check with the government. And basically, such structure is very, very rough. They require the AIGC service provider to do the security check by itself to ensure how they could make the content safe and non-discrimination, and also, the most important thing, to ensures every mechanism and measures could be done if some dangerous content or some dangerous content come out. So that's the general structure of the AI measures. However, we do not see some specific penalty or specific implementation measures on this aspect. So just to give a general guideline that you cannot do that, you cannot do this, and the government have a special authority that could have extra official power to inspect from the technology level to the service provider, to the service level, to check, to inspect all kinds of things. And they also require the service provider to supply a kind of a way for everybody to report the potential dangerous or flawed content to the authority. And the most, I would say, the consequence for the violation of this measures is would be the termination of the service or suspend of the service. So that's the general idea. I would say from this kind of measures that the government do not want to put a lot of restriction on this industry, and the main idea is still trying to encourage the development of the AIGC technology, as we know that such kind of area is very advanced area that a lot of countries are they're highly competitive area. So the Chinese government do not want their own company or their own industry lay behind the world. So this measure just give some general principle, and still they give a lot of flexibility, a lot of room for the technology company, also the service providers that based on AIGC to have their own room to grow and to develop. So that's the basic general situation in China. Yeah. And I would give the floor to the Susie too.
That's brilliant. Thanks, Wei. So, I mean, it sounds like similar to the UK, and we'll come on to the US in a minute. China seems to have taken that principle-based approach, but perhaps it sounds like they've gone even further in really considering the roles and how accountability might feature with the roles within AI, and particularly, you know, things like the security checks that you've talked about. They seem to have gone perhaps a little bit further than some of the jurisdictions in considering those areas or perhaps regulating those areas, which is really interesting. Brilliant. Well, Kritika, I think I mentioned there about the US and the UK taking a similar sort of principle-based approach. But it, you know, be interesting to hear from you about how the US is dealing with regulating AI at the moment. And Sean.
Sure. I'm happy to report from the US, although in the US, we don't yet have a fully baked law or bill at the federal level. As most of you would know, laws are usually at the federal level as well as the state level, with each state regulating its own, various areas, depending on the usage at the state. Whether the state wants to follow any preset federal guidelines or whether they want to have their own sort of how we see for the data privacy legislation, which also does not currently have a federal legislation, but several states are coming up with their own laws. While there's no federal legislation as yet in the US, US back in I think 2021, the US had established an initiative. The US government had established an initiative called the National Artificial Intelligence Initiative, which basically was to coordinate the task. Their task was to coordinate a program across different federal agencies to basically give impetus to AI research. While this initiative does not and has not resulted in any legal regulation of AI, from an innovation perspective, their efforts have sort of established guidelines and created opportunities for the development of AI, including with in coordination with other countries. More recently, after the buzz of sort of the generative AI that has taken us all by the storm, the White House has held congressional hearings, has invited the large companies that mainly deal with big data, such as Meta, Google, IBM, etc., who have been asked to basically provide testimony as to what the status of AI is in the US, where it's headed, and how it should be or could be regulated. Again, while no law has come out of this, the White House has established a set of principles that's called Blueprint for an AI Bill of Rights, which is not so much as of a regulation, but more of sort of a set of 5 principles that encourages transparency and disclosures and sort of ethical use of AI. In addition, some of these companies that I mentioned have voluntarily signed commitments to manage the risks posed by AI. So these are all sort of voluntary measures that companies are taking, with the end goal being, or with sort of the path going towards the direction of enhancing transparency and ethically using AI or generative AI tools. I should also mention that while this is all happening at the federal level, the states, I think, have gone far beyond in many instances, and in several states. We have been seeing several legislations in the areas of what they call high risk assessment areas, like healthcare, insurance, any government agencies within the states. Employment is another area which we've seen quite a bit of legislation in relation to AI on. Most recently, I guess, of note is the one that New York passed recently, which prohibits the use of any automated AI-powered tools that would cause a bias in any hiring or employment decisions. And so a lot of states are following suit in similar contexts, and we are seeing a pattern of, most of these legislations seeking to eliminate bias that any of these automated tools might cause, and are encouraging transparency and the ability to opt out of any instances where such automated tools might be used. I think one sort of anecdote which I thought was interesting was there's a law recently, or there's a bill that was introduced in Massachusetts, which was actually entirely generated by ChatGPT. Interestingly, to regulate the use of ChatGPT. So it'll be interesting. We're keeping an eye on how that goes. But
it'll be great to hear what the law is that it comes up with for itself.
And if it gets passed that way. Maybe our legislators will run out of jobs.
Yeah, and
Brilliant.
I can add.
Yeah, thanks, Sean. I was going to say, over to you.
Yes, thank you. And I can add that while we wait for federal legislation or regulation, agencies and parties have relied on existing laws to apply pre-existing concepts to real-life cases. A couple examples I can give are that the U.S. Copyright Office has denied an application that named an AI as the sole author of a drawing, and they did so based on sort of the concept that an author under the U.S. Copyright Act can only be a human. It cannot be a machine or any other thing. U.S. Patent Office has also held a similar decision denying a patent application naming an AI as the sole inventor. And they did so again relying on the pre-existing definition of the term inventor under the U.S. Patent Act. So we're applying these existing laws to these brand new cases, really. At the same time, Congress and agencies are having multiple sessions, listening sessions, and so on to gather public comments on sort of their ideas of what the new regulation and legislation would be. So one example I can give is the U.S. Copyright Office issued a notice of inquiry at the beginning of September, which is basically their way of asking about the public's opinion on various AI-related issues. As of yesterday, there have been more than 9,000 comments submitted to the Copyright Office, and that, for your reference, is very high and unusual. So there's a lot of public interest, a lot of governmental interest for these topics.
No, that's brilliant. Thank you, Sean. In fact, I think IP in particular, I think maybe we'll revisit that topic shortly, because I think it's a key feature for all of our jurisdictions when we're looking at AI regulation. But it was really interesting. So I think both Kritika and Wei and Sean, you've all sort of drawn out the principle-based and I think industry-focused approach that our jurisdictions are taking, and certainly the UK is very similar. But I think, Peter, when we look at the EU, I think the EU perhaps has taken a slightly different approach with the proposed EU AI Act. So, you know, be interested to hear what the motivation for the regulation is, you know, what that EU AI Act looks like, and certainly the interpretation in Denmark.
Yes, for sure. I can understand there's a lot of waiting here. There's also a lot of waiting in Denmark and the EU country. We're waiting for the Parliament to pass the EU Act because it's not passed yet. We were waiting for maybe they would pass this fall, but I think the last meeting will be in December, and there's a possibility that it will not be passed there either. So we will wait until 2023 before it's passed. But yes, we are waiting on 4 areas right now. We actually has one law passed, the Digital Single Market Act, which has a regulation for text and data mining, which has to be implemented in each EU country. And it introduced a new form of permission for text and data mining on what is acceptable on public websites and so on, and introducing an opt-out option. So you can opt out, saying that you are not allowing any text and data mining, but if you are not making an opt-out statement, you have accepted that others could copy and scrape your data and use it for text and data mining, for text and data mining only, of course. So this has already passed, but it has to be implemented in each country. And there's in Denmark a lot of discussion right now how to use this opt-out possibility. Should it be human readable text or computer readable text, and how to opt out, how to do it in practice. So, but the major regulation, the EU AI regulation, we are waiting on this, and this is introducing different level or types of use. We have something we call unacceptable risk AI used in cognitive behavior manipulation, social scoring, and real-time biometric identification systems. This will not be allowed at all. That's unacceptable risk, and we are not allowing this at all in the EU. Then we have the main area which has to be regulated with call it high risk. It's where you use AI systems in different products, often as a kind of security or handling part in a product. For example, if you embed AI in toys, aviation products, cars, medical devices, and so on, this will be a high-risk system. And then they have a lot of other high-risk systems that could be education training, actually, employment and management tools, law enforcement, and also use of AI in the public sector for deciding whether to grant any subsidies or to pay out any money to the citizens. This would be a high-risk system, and that would be the the main area to be regulated by the EU regulation. Then this summer, something new were introduced because the AI regulation and the proposal were not taking into consideration all the new things going on, the generative AI, the ChatGPT, and so on. So in the summer, they actually introduced a new level or a new area called general purpose AI or foundation model AI, which also covers the generative AI such as ChatGPT, and introducing a registration duty, introducing a transparency obligation. You have to be transparent how it's trained, on what basis it is trained. Is it trained on copyrighted protected training material? You have to make a summary, and you have to develop such general purpose AI in a way where you mitigate any risk of breaching EU law, especially the GDPR and copyright infringement. And then you have to actually label the output of such AI. So you have to label it's generated by, for example, ChatGPT. So it's not hidden in any way that this output is actually made by AI. So that was introduced this summer. So and the other obligation to this high-risk AI is requirement for security, for monitoring duties, to risk assessment, and the use of data and training data. It has to be transparent. You have to document this, and you have to make self-assessment and also register high-risk systems by the EU. So there's a duty to actually register the systems and to submit information about how it's trained, the transparency, how do you risk assess this use, and so on. And it's an obligation you will put on providers and users or deployers of those systems. So regardless of the system is operated outside EU, if it has any impact in the EU, you have to follow those rules. So and of course we are waiting on this, and I mean I think it's pretty clear that we will not see many individual laws on each country. For example, Denmark, we have 5.8 million citizens in Denmark, so we won't have our own regulation in Denmark, and I can of course not speak for every EU nation here, but I think all the countries in EU, and especially the Nordic countries, the Scandinavian country, we will not see any specific Swedish or Danish legal acts here, because it doesn't make any sense that a country with 6 million people should have their own AI regulation. So we are depending and leaning towards the regulation in the EU. What we also are waiting for in the EU is the AI Liability Act, which will introduce some kind of liability scheme here, very, very inspired by the Product Liability Directive we have seen since 1985. So I think we will introduce some kind of AI liability. It's a bit stalled right now, but actually introducing a presumption of causality and presumption of liability for high-risk systems. So we will have a strict burden of proof if such high-risk system has damage, person injury, or other kind of damage, and there will be an obligation for disclose any information about the AI system. So there will be a burden of proof as soon as you can prove that you have a damage. Then there will be a burden of proof on the shoulders of the providers or the users, deployers of this high-risk AI, and they have to actually prove that they are not responsible. We don't know when this will pass, probably following the AI regulation, so probably in 2024, I think. The next one is also regarding liability, because we are up to having a new Product Liability Directive, replacing the old one. The old Product Liability was from 85, so it's an old directive, and we had a lot of discussion in the EU. Does a Product Liability Directive, does it cover software and AI? And I think the broad opinion on this was that the Product Liability Directive didn't cover software as such or AI systems as such, but what we can see from the new upcoming Product Liability Directive will be that it actually states that this will also cover software and AI system. So if AI system is enabled in products or in software, it will also cover the product liability of such systems. And it's the same as the AI liability. Actually, it's a presumption of liability regime, and it puts the burden of proof on the importer or the developer or the deployer that will have to prove that they are not responsible for any defects. So and this is also coming up, and I think also in 24. So we're looking into a very busy year next year, I think.
Yeah, I absolutely agree. And it's interesting what you say about the product liability sort of regimes. You know, I think to date, all the jurisdictions have been trying to apply existing frameworks to AI. And, you know, we've had all those discussions around consumer legislation. You know, how does consumer legislation apply to software and things? And it's this tension between the development of regulation as technology changes and supporting innovation. So that's really interesting. So obviously the UK at the moment doesn't have any AI specific regulation. We've very much taken a principles-based approach, and I think you know, similar to the US and China and Europe, you know, we are all signed up to the OECD principles, which are, you know, a set of principles which I think there's 42 countries signed up to at the moment, which are really there to support policymakers, I think, you know, nations with looking at AI and how we develop AI in that sort of safe and compliant and ethical manner. So we've got 5 principles that underpin our framework that are taken from the OECD principles loosely. So sort of safety, security, accountability, which I think we've sort of all touched on, contestability and redress, fairness and transparency. I think that's 5. And these really are meant to sit across all of our industries, but we are, I guess, relying on our existing regulatory bodies as to how they implement and apply those principles to their particular industry and sector. So, you know, similar to you saying it's going to be a very busy 12 months, Peter, I think, you know, in the UK, we're expecting over the next 12 months to see some of those regulatory bodies like the ICO, the CMA, for example, publishing guidance based on those 5 core principles around how industries should be dealing with AI development and how they should be applying that. And that really is driven by a white paper that was issued. Since the white paper, the House of Commons has suggested that we may want to look at AI specific regulation or legislation. I don't know how quickly that will materialise, if at all. I think it's in the very early stages, but I think there is a bit of a concern that if we don't address that with something specific, then we might perhaps fall behind from where, you know, the US, China and Europe are in terms of publishing perhaps more robust AI specific frameworks and legislation. So we just have those non-statutory principles at the moment. And I think, Peter, I think you mentioned a really interesting point around language. So when you were talking about general purpose AI and foundational models, the UK has termed specifically for the AI Safety Summit the term frontier AI. Whether it'll be adopted beyond the Safety Summit, we will see. But that's really talking about perhaps those wider used general purpose advanced AI models. And I think really when we're talking about AI today, that's sort of what we're looking at. It's that general purpose and perhaps more advanced AI capability as opposed to perhaps predictive AI, for example. But it does raise a very interesting point around the definition. And actually, there doesn't seem to be any universal definition. And when we talk about AI, what that encompasses is actually very broad. Brilliant. Well, perhaps it might be worth coming back just to touch again on IP. I know Peter and Sean, you both talked briefly about IP there, which was really interesting to hear. And I think this is a driving factor behind all of our jurisdictions when we look at regulation. And certainly, Sean, I know in the US there's been a lot of talk around litigation. I think John Grisham, the author, came out this week and sort of said, actually, he'd be looking at a lawsuit, as a content creator, the idea that his content is being used to train AI models and perhaps in breach of copyright. So how do you think that will play out in the US?
Yeah, thank you, Susie. Right now, there are just a lot of different voices and opinions that are being expressed. In one of the congressional hearings that I attended, we had two sort of a pro-AI panelists and three traditional content creators who were generally opposed to AI. And even the vocabulary they were using were different. So on the pro-AI side, they were calling it AI training. The three traditional content creators were calling it AI ingestion. So you can sort of see that they're not even speaking the same words. And one interesting anecdote there was one of the panelists was a former general counsel of the US Copyright Office who expressed his opinion that, in his opinion, that AI training is likely considered fair use, which is a defense to copyright infringement claims. A few days later, a different former general counsel of the US Copyright Office published an open letter saying he completely disagrees, that he does not believe AI ingestion is likely fair use. So while this public debate may not be as dynamic as, say, Tottenham versus Liverpool, it is certainly interesting and informative that even very highly sophisticated and well-informed copyright lawyers disagree on even specific issues. So I mentioned earlier that both Patent Office and Copyright Office have rejected applications that named AI as inventor and author. The Copyright Office has published a guidance saying that while AI cannot be a sole author of a work, human-created but AI-assisted work could perhaps be protected. So we have some guidance there. And Patent Office has not published a guidance like that, but it has stated that it plans to use AI in its own operations. So, for example, it can use AI for patent prior art search, or it can use AI to categorize or classify trademark applications based on what kind of goods or services they offer. So there are a lot of questions that are open, but we're getting more and more information from cases and hearings and guidances.
Yeah, that's fascinating. And Wei, what's it been like in China in terms of content creators perhaps being concerned about how their copyrighted works might be used in both training AI, but also AI, ownership of IP and whether AI or AI assisted output might be capable of perhaps slightly different intellectual property protection?
Yeah, thank you, Susie. Actually, in China, we don't have heard a lot of a complaint from the content creator about how the big company use their content for the AI training, because we don't know whether they use or not. There's no transparency in this kind of industry. So that's the reason why the new AI measures and put transparency as a very corporate simple in the for the regulator of the AI. That's kind of a problem. I don't know what the system in the US, but in China, basically, it would be impossible for the content creator to know whether their content had been used by the company to train their AI model or not. So that's kind of a problem. And on the other aspects, and we don't have that many cases about the people to use the AI assisted content or the AI generated content for the application of the copyright. However, we do have a judicial precedent about Tencent. They trying to to claim a copyright infringement based on AI assisted content, and I know the local courts support that cases, but part of the reason is because the Tencent headquarters is located exactly in the place where this court is located. So there might be some local protectionism involving in this kind of cases. So in general, the general trend of the judicial environment in China is not support the AI assist, whether it's AI assisted AI generated content as a copyrightable work enjoy the protection by the copyright law. However, the question came as follows: is how could you tell or identify whether a copyright or whether an image or whether a kind of works is generated by AI or not? That's kind of not a problem because people just get the image or get the works from the AI, and they could claim it is a work of their own. So that's another problem. How could we tell whether a copyrightable works is generated by human or AI? And how could we use the technology to make some annotation on such kind of works? That's another kind of a discussion in the area. So a lot of things is going, unknown route. So we still need to observe how the things is developed. So that's the general idea about your question. Yeah.
Yeah, I think you're right, Wei. We've sort of got AI assisted, and then we've got, AI where we're talking about fully AI generated output or content, and it might be that they're treated differently. Certainly in the UK at the moment, there is nothing to suggest that any output generated by AI would be able to be, that the AI would be able to be considered the owner of the design. But again, we've not seen any litigation. We've not seen this tested in court. So it'll be interesting to see how this develops. And certainly as AI models become more advanced, I think we will see this tested in the courts, definitely. Brilliant. Well, I'm going to sort of turn to a bit of a different topic and question now in terms of how we're dealing with AI as law firms. We're all businesses at the end of the day, and certainly at Ashford's, we've had to look at AI. ChatGPT, I think, forced a lot of businesses to consider how they might be able to use AI internally. And I know we've sort of taken a relatively cautious approach, just given the nature of what we do. We're obviously a professional, regulated industry. So certainly we don't want to be using personal data or confidential information in AI models like ChatGPT. Kritika, really interested to hear how Dave Pitley's dealing with that, because I think that's something that you've been quite involved with.
I have. Thanks, Susie. I actually chaired the firm's AI committee, and we have in the past few months been very busy thinking about what position the firm needs to take in this whole innovation versus responsible usage versus professional responsibility spectrum. We initially, back when, earlier this year, took a more conservative approach to prohibit the use of any generative AI tools while we were still deliberating on what the policy should look like. But more recently, I would say last month, the firm announced a policy which basically encourages the use of generative AI tools for incidental work, which is non-client or non-firm work, but subject to certain guardrails, which basically are, to maintain confidentiality, to make sure that we're not using any client or firm confidential materials, to make sure we're reviewing the work, the output, because of the inherent issues that have been identified when we're using any generative AI tools, and also to err on the side of, again, disclosure and record keeping when any generative AI tools are being used, and we're interested to see how the firm reacts as a whole to the policy. Again, it is an encourage. We've taken the position of being encouraging because, like it or not, AI and generative AI is here to stay. It's been here for a while, but in the legal industry, we're seeing specialized generative AI tools, being developed by the day. It is bound to be adopted in some way or form. And the position of the firm is that, we want to encourage people to learn how to use, because we follow the mantra, which is, AI will likely not replace lawyers, but lawyers who effectively know how to use AI will probably replace those who don't. So that's where we stand. Point.
That's a great mantra. I really like that. And actually that's a great approach, because a lot of our jurisdictions are trying to take a pro-innovation approach with regulation. And I think the word regulation sometimes is seen as synonymous with perhaps hindering innovation, but I think certainly in the technology sector as a whole, and certainly when we look at AI development, we don't want that to be the case. It's, these tools are fantastic and there's a lot of efficiencies to be gained with using them. So I think, like you say, it's trying to look at how we can use them in a manner that is safe within the services that we're offering. Peter, I think Beck Brunn has certainly sort of taken on perhaps using AI tools within the provision of legal services. How have you found that?
Yeah, we have been using testing and using Luminance, the AI for scanning large amount of digital documents, especially in M&A transactions, of course. And I have prior been partner at the international law firm Bird, and they also use Luminance. So we tested Luminance and had also used it, but we also see some issues or some challenges there for especially maybe countries where English speaking is not the main rule, because we look into some challenges about the training material, because Danish is a small language, so to speak, and it is difficult to have the right amount of data to train it, because we only have to train on Danish. More and more documents in the bigger Danish companies are also in English, but a lot of material is still in Danish, and it's actually hard to get the right size of data volume to train upon. So that's one of the problems. The other problem was that our transaction in Denmark are mid-size, small and mid-size often, and it's too expensive to set up an AI to crawl through maybe 200 employment contracts and 20 major supplier contracts, for example. It's much easier, quicker, and also less expensive to have a junior associate just to look through those documents instead of setting the whole thing up. Of course, if you have large volume of documents to have to search and scan, that could work. And the last problem we often did face actually was pure data quality. So it's depending on the data being digital. And in Danish firms, most of the material is still not 100% digital. So you have to have junior associates and associates going through anyway, because it is pure data quality. It could be scanned PDF documents where the quality is pure. Sometimes all the even pages are missing, or the uneven number pages are missing, or the last 20 pages are missing. So it's very difficult to use it due to pure data quality. But we did actually, for a couple of months, introduce a guidelines for using of generative AI, ChatGPT, and so on. And it's, what's usually happening in the law firms, the old partners saying, well, we're not using it, asking the younger associates saying, yes, we are using it. So we actually have faced that problem. We had to have some kind of guidance. And it's some of the same things that Critica actually mentioned we have the four main issues. The client confidentiality problem. You have to get rid of any confidential information in the input or the prompts to the ChatGPT or the DeepL translation, for example. So I have to make sure that every client information is erased. Then in Denmark or in EU, we have the big elephant in the room, the GDPR, because you have to get rid of any personal information. And one of the things we also set up, the third thing was that you're only allowed to use it where you have the knowledge or expertise. As an example, I can use it for translating a contract from Danish to English because I can evaluate and assess the translation because I can read and understand English and can do it myself. But I'm not allowed to use it for translation to Spanish, for example, or Russia or Chinese even, because I don't have a clue. I can't assess and evaluate it. And that was some of the problem we faced because people were saying, hey, it's great. We can use it for example, I can use it for employment law. I can use it for employment contract. I don't know about it, but I can ask ChatGPT. And we actually made a ban on this because you're not allowed to do it. I can use it for IP and IT stuff because I'm an expert. I cannot use it for employment or tax advice. I have to refer those to the tax people in my office. I'm not going to use ChatGPT. And the fourth area is very important for us because we have the rules of mandatory lawyer professional liability insurance. All dangerous devices in Denmark has to be insured, and you have to insurance, and goes for airplanes and wild animals and cars and also lawyers. So lawyers are very dangerous species, so they have to have a mandatory insurance. But the problem with those insurance is that it's a lawyer professional liability insurance. So we have to put our names on the output. We have to assess and evaluate the output, and it's the lawyer's output because the insurance is not covering AI. So if it's produced by AI and just pushed through the system as an AI output, there's no coverage in our insurance. So we have to make sure that every output is named by a lawyer and actually labeled as a legal advice.
That's really interesting. So it seems like there's sort of two themes, I think, coming out from what we've heard so far. The first is, data. I know we've looked at inputs from an IP perspective, but actually we've not touched on data today, probably because it needs its own entire session. But when we look at input into AI models, data and IP are huge considerations. So it seems like both Beck Brun and Dave Pitney are taking that similar approach of absolutely not allowing personal data and confidential information to be used within AI models. And the second, Peter, I think, was accountability, which again we touched on earlier in the webinar, but really important. And I think a lot of businesses, certainly in the legal sector, and I think in other sectors as well, are still not comfortable using AI models entirely independently, and they do still want that human element. And I do wonder whether some of that's driven by we're not quite sure where accountability sits when we're relying on AI tools, perhaps. And you touched on that great point around insurance. Wei, I'm going to come to you next, and then Sean, I'll come to you as well, because I think it's a really interesting topic. How are you doing this at Wei-Hinder?
Yeah, that in China we are not allowed to use ChatGPT, first of all. So basically, we have some domestic AI models, and due to the strict regulation and originally not open to the relevant public. It's just recently Baidu just released its AI mode. So legally speaking, for pure legal compliance aspects, we do not have much of the choice. But we know that in the market, a lot of the AI assisted tools that have been provided to the law profession, basically in the area of the legal research and the simple Q&A to this simple legal question. However, it turned out that the tools doesn't work very well. I don't know it's because of the AI modes not very adapted to the Chinese language, or is there any other defect? But sometimes we notice that if you want to, there's a kind of two purpose in the legal professional. One side says that eventually that AI tools or this AI assistant tools could replace some junior position of the legal professional, and they could just act like some a basic trained paralegal. And the other side, they said they never achieved, because the big AI model cannot be well adapted unless you have been fine-tuned with the training material specifically in your area. That's a big kind of job that I don't think a single law firm could do that perspective, do that kind of task. So basically, I would say that the AI model would be a lot of it would be mostly used for the lawyers who do the foreign, clients, because they have a very good way to polish your language or your wording from the Chinese to English. That's a lot of my friend told me that. And when coming to the legal research and when coming to the legal reasoning, the result is not satisfied. And as you know, that AI just fabricated a lot of facts, a lot of reasoning that doesn't exist in your legal system. So that's a big problem. I don't know whether it is also the situation for the Western world, when you do the legal research or do the legal reasoning, whether the result come with accuracy. But in China, the situation is a disaster. So at the time being, I don't see widely application of the AI tools in the daily work of the law firm. But in the long run, we see a lot of the company are working on that, involving some law firms. We'll see what will goes eventually. Yeah.
Yeah, brilliant. I think like we've mentioned, I think a lot could change over the next 12 months, both in terms of businesses and how we're using it in the legal industry and other industries, and also the sort of regulation. I think I saw Francesca just remind everyone, if anyone's got any questions, please do put them in the Q&A box. We've got about 5 minutes left, so we're going to start wrapping up, but we do have time for any questions, so please do pop them in. We might be able to take a couple now, and any that we don't get to, we will follow up with written Q&A responses, which will be anonymous when we publish those. Brilliant. So we've got 5 minutes left. We've sort of talked about how the regulation is developing and also how we're dealing with it as businesses ourselves, as law firms. So I guess it would be really interesting if perhaps just each of the panelists could give, any tips for businesses around what they should be thinking about or looking at internally for their businesses if they're starting to use AI tools, or if anyone's got any tips for suppliers who are using AI, developing AI within their products and services. So any top tips for businesses looking to use or suppliers who are incorporating and developing AI? Sean, I'm going to kick off with you.
No, thank you. So I would echo a lot of the sentiments discussed already, and to have the human element stay in whatever the decision-making process whenever it involves some kind of generative AI, because we don't have any specific regulations or legislation, at least in the U.S. There's just a lot of uncertainty. And that means great opportunity for us lawyers to help our clients in making decisions the right way. One anecdote I can share is I was playing with DALL-E, the graphic generative AI, and making dozens of drawings involving a lawyer. And literally every drawing except one featured just a male lawyer. And the only exception was when the prompt included the term lawyer and a dog, and a dog was a lawyer. So maybe that's not even an exception. So that's kind of a silly, maybe fun example there. But if you're using AI in making employment decisions, that kind of bias can create a huge liability. for your company. So bring in any kind of outside or inside assistance, whether that's employment lawyers or IP lawyers, commercial lawyers, so that we can spot any potential issues and navigate this uncertain time.
That's great. And there's obviously so much that we've not been able to delve into today. You know, bias, we've touched on it through our discussions, but it is a huge concern when we look at AI and when we're looking at the input and the training and the, you know, what we're using to develop these AI models and how that potential bias might develop it and how that materializes with the output. You know, that is a huge topic of discussion and a huge concern. So that's a really good point. Wei, any sort of top tips from you?
Yeah, just one tip for the business operator that is interested in develop or provide the AI service tools in China, that you need to, you know, choose the reliance AI model supplier. Especially, you need to check whether it has been recorded with the authority or not, because we know that recently some service providers, they developed apps using the ChatGPT, and which is forbidden in China. And we know that the PSB, the Public Security Bureau, had launched the investigation, and so that's kind of a sense. We know that there's a lot of way to bypass the firewall. So it is possible to still supply service with the AI model from other country, but it is still in a blurred line. So be careful about that, and trying to, you know, choose the AI model that had been recorded before the authority. So that's a kind of a safety tips for all the business operators that are interested in the market of China. Yeah.
Brilliant. No, that's a really practical tip. Thanks, Wei. And Kritika.
Well, so if I was advising a business, I would say, you know, consider having a policy in place, because ultimately, regardless of how the tool is developed and what measures the developer has taken, and I'll get to that in a second, but ultimately the buck sort of stops at the user. It's the user's responsibility to make sure that they've reviewed the terms of use of these tools, they've reviewed the privacy policies of these tools, they're using content to provide inputs, and they're using the outputs in a way that does not violate any third parties' IP rights or confidentiality. You know, they maintain confidentiality obligations. So at the end of the day, it's the user's responsibility, and as an employer, the business's responsibility as well. And from a developer's perspective, someone who's supplying generative AI technology to others, I think what we're seeing generally, the trend is that transparency is, I think, the key. Disclosures as to how the model has been trained, how the model has been coded, what it is based on, what kind of controls have been taken to in developing that AI model and training it, what kind of data has been used. I think that the earlier companies can start sort of keeping records of those, the better. I think that's where the train is headed. That would be my 2 cents of tip for companies.
Yeah, that's great. And I guess not just for transparency, but also for learning. You know, if we can go back and reflect on how something's come about, you know, we may be able to change it and keep improving. So yeah, really good tip. And Peter, any sort of top tips on either side from you?
I mean, yeah, it is transparency. That's the key word. You have to be ready to be transparent, and you keep your, so to speak, your books open. And of course, if you are doing business to business, you can rely on limitation of liability and so on. You can write your terms and so on. What you cannot write you out of is the GDPR, and that is still the big elephant in the room in the EU, because we have all kind of personal data in the training material, personal data in the prompts, in asking the AI question, using the AI, but even using the AI is also creating a registered personal information. We have a huge case in Denmark because the Danish schools were using Chromebooks, and of course the pupils could use the Chromebooks for all kind of infringing things going on in the classroom. But one of the issue was that the school boards actually offered those kind of products, the Google Chromebook, to the pupils, and even the registration of the use, when a pupil entered and opened the Chromebook connected to the internet, Google will actually register the opening of the Chromebook, the connection to the internet, and not monitoring the actual use, but actually the technical use, what the Chromebook is used for, and when the internet is disconnected. And even those few information was personal information, they said, and you have to make that totally clear for the pupils, and have to have the consent from the parents, and you have to have fully transparency. And that's the problem also by using the AI. If you make AI available for your employees, as an employer, you are suddenly being a data controller, and you have to make completely clear for the employees how and when are you being registered when you're using, for example, ChatGPT or DeepL or some of the other AI solution. So GDPR is a huge challenge in the EU. And just for the last advice or last example, the EU Commission has actually published a
Oh, sorry, Peter, you've gone on to mute. Not quite sure how that happened. You were saying about your last tip.
The last tip was that European Commission has actually published, it's only a draft for now, but drafted a proposal for standard contractual clauses for procurement of AI by public organizations. I know it's for public organizations, but I think it could also be used for the benefit of private organizations, of course. And there's two standard contractual clauses proposals, one for high-risk versions and one for non-high-risk versions. And they're actually quite good to get some understanding of and maybe inspiration of to put into your contract if you're going to buy any kind of AI system. So they're drafted, and it is called Procurement of AI Community by the European Commission. So that's somewhere where you can get some inspiration for your contractual clauses, I think.
That's a great practical tip. Brilliant. And I guess from me, similar to what we've all been saying, I think it's just stepping back and really considering the use case, and I think documenting that in the policy. How we use it, what the risks are. I think, Peter, you mentioned insurance, looking at some of those practical things. And certainly we've seen people using AI tools that actually are perhaps not compliant with some of the security certifications or accreditations that they're using, for example. So Cyber Essentials and ISO, some of those prohibit, for example, I think beta versions of things. And, ChatGPT there was a beta version and people were using that quite freely. So I think it's really just taking a step back and considering some of these issues, how we can use it safely. And I think making sure those policies are working documents and reviewed regularly, because it's such an area of change. And hopefully you're learning from each other, because I think with any new area, it's all about sharing the information and hopefully learning and developing so that we've got good practices. We have run out of time. There is one question, so I am going to ask it because I know a lot of people will have dropped off, but hopefully we can share the recording and then I will pull the webinar to a close. So in terms of the question, it was really, given the close relationship between the UK and the EU, Are there any difficulties expected for UK companies who may have an operational presence in the EU following the implementation of the EU AI Act? And I guess, will they be affected by the EU AI Act? So, Peter, really, I think a question for you in terms of how you think the EU AI Act will affect UK companies who are operating in the EU.
I think every company outside EU, if they're operating in the EU, if they're providing the AI tool into the EU, they have to comply with the rules. So regardless whether if they're placed in China or Mexico or the United States or UK, they have to comply with the rules if they're providing the system to EU citizens or people within the EU. So you're looking for some kind of geo-blocking or something if you want to make sure that they are not accessible for Europeans, but if you are making it accessible for Europeans or EU, then you have to comply with the rules. Yeah.
And I think that's a really nice comment to wrap up on, because I think it really demonstrates how regulating this area is really going to transcend jurisdictional regulation. So the idea that we've got some of these global principles like OECD, we've got opportunities like the Safety Summit where we can come together globally and look at how we deal with, such a complicated technology such as generative AI is, really sort of sums up some of the difficulties and some of the opportunities for us to work together globally. So thank you to all of our panelists, and thank you to everyone that's joined. Like I said, please do, the Q&A function will be open for a little bit longer. So if you've got any follow-up questions, let us know and we will submit answers to those. But otherwise, thank you everyone for joining, and thanks to our panelists.
Thanks, Susie, and thanks everyone.
Thank you, Susie. Thanks.
Thank you, Susie.
Thank you all.